Reprise du débat, l'honorable député de Bay de Quinte.
Resuming debate, the honourable member for Bay de Quinte.
Mr. Speaker, 34 years ago, the Supreme Court said that privacy is the heart of liberty in a modern state. In the words of Justice Gérard of the Supreme Court of Canada in 1988, it is worthy of an individual, it is worthy of constitutional protection. All Canadians are worthy of having their privacy respected, and it is our duty as parliamentarians to do our best to protect the Canadians' privacy rights, especially as we struggle so much for it today. C-27, formerly C-11, is designed to update Canada's federal privacy sector privacy law, the Personal Information Protection Electronics Documents Act, or PIPEDA, and to create a new tribunal and to propose new rules for artificial intelligence systems. It's a reworking of C-11, and it has three components: the Consumer Privacy Protection Act, Personal Information and Data Protection Tribunal, creating a new tribunal, and Artificial Intelligence and Data Act. This bill applies to Canadians' private rights. It doesn't apply to CSIS, RCMP, or CSE. That and other government-held data is governed by the Privacy Act. Privacy laws for Canadians have not been updated in 22 years, and Europe updated the General Privacy Protection Regulation in 2016. So 22 years ago, when we last updated this act, the member from South Shore, St. Margaret's, was turning 21 years old. But, you know, we had big changes, big changes in society back then. Back then, we had just gotten past the Y2K scare, the time when we were looking at what's going to happen when over to computers from 1999 to 2000 when the clock changed over. I remember being in certain areas and you didn't know if the power was going to go, what was going to happen. People listened to music on CD Walkmans. Apple was over a year away from launching a cutting-edge new technology called the iPod, and less than 30% of Canadians actually owned a cell phone. The most popular cell phones were the Motorola Razors, the flip phones. Nokia had a brick phone where you texted using the number pad, and almost no web browsing capabilities, and the most sophisticated app was called the Snake. A fledgling Canadian telecommunications company was just starting, and it was called BlackBerry. So that's how long it's been since we've updated our laws. And today, 22 years later, data collection is getting more sophisticated and surveillance is more of the norm than the exception. Apple Watch announced this week, or a few weeks ago, it can track and tell when a woman is ovulating. What is concerning, and we're going to talk a lot about data for good and data for wrong, is that this technology can tell if a woman skips a cycle and then can identify if there's been a miscarriage or an abortion. So this is very concerning when we look at this. Our Fitbits, our Webbit history, our Apple phones themselves can tell us how many steps we did a day. And sometimes if you're in Parliament, it's about 10. Sometimes you want to get home, if you're door knocking, it's about 25,000. Really important, but that information is also letting those regulators know where we've been and where we're going and where we live. Facial recognition technology can identify a face like a fingerprint, and sometimes that's been good. We've heard from law enforcement that uses that sometimes for human trafficking, but sometimes that's wrong when we're identifying people in a street and identifying their name and their data and again where you've been. Think of Minority Report. When everywhere you went, you're identified, it didn't matter where you're going or where you've been. That's something that can happen with facial recognition technology. And Google and Amazon listens and collects to our data in our bathrooms, in our living rooms, in our kitchens, in our cars. How many times have we just been involved in conversations and Siri says, sorry, what was that? Siri is always listening, Amazon is always listening. And speaking of cars, they are cell phones on wheels. When you connect to a rental car, and a lot of us rent cars, and you see 5 or 6 other phones that have been in the history, well, that car has downloaded all the data from your phone into that car. So a lot of times right now, if you see that in your rental car, that car holds your information, which is very, very concerning. There's many examples where it's hurt Canadians in the last several years. Tim Hortons, 2 summers ago, had a data breach where it collected every time you rolled up the rim. It also told you and told Tim Hortons where you went afterwards. If you went home, where you were staying, it collected all that data, and it was a big problem. We studied in the Ethics Committee facial recognition technology, and there was a company called Clearview AI, which took 2 billion images off the internet, including a lot of ours, and just gave them to the police. So there was no consent. The information just went, and it ended up in the hands of law enforcement. TELUS Data for Good during the pandemic. TELUS collected our data, knew where we went, if we went to the grocery store, the pharmacy, if we stayed home or not, and it just gave it to the government. It was called the data for good, and they called it de-identification. And I'm going to talk about how that hurt everyone later. And lastly, doxing, or using personal information to try to out people. Give, Send, Go is a big one, where it gave a company, and it was a US company, but gave information to people who donated to different causes or events. And at one point, Google had identified all those donors on a website and told them exactly where they lived. So everyone's information, when they donated to a company, was given then and outed, and that was terrible. Surveillance has not just resulted in a wholesale destruction of privacy, but mental health crisis in children and youth as well. And I'm glad to hear the minister speak about children and youth, because data has certainly, and it continues to affect them. Canada's federal government has repeatedly failed to take privacy seriously and construct a legal framework that protects the rights of Canadians in the digital age. This bill normalizes surveillance and treats privacy not as a fundamental human right, not even as a right to consumer protection, and to make the point very clear, nowhere in the document for C-27 does it state that privacy is a fundamental human right. It should be the crux of new legislation to update privacy laws, if not the outward premise, with a statement hammered in the preface till the end in Bill 27 and followed through to the entire document. But it's not there. It's nowhere. And therefore, it holds no value that this bill does not use the statement from the onset. It should be the pillar to which the bill is designed and led. Only a strong bill will ensure that Canadians' privacy rights are protected, and by omitting it, this bill is very weak, making it easier for industry players to be irresponsible with your personal data. It's ironic, as Canada has signed on to the UN Declaration of Human Rights and the International Covenant of Civil and Political Rights. And that's where the bill starts and ends, with its failure to properly address privacy to Canadians. Conservatives believe that Canadians' digital privacy and data needs to be properly protected. This protection must be a balance which ensures Canadians' digital data is safe and that their information is properly protected and used only with their consent, while not being too onerous to be detrimental to private sector business. You see, it's a balance. Now let's be clear. We need new privacy laws. In fact, it's essential to Canadians in this new digital era and to the growing digital future. But C-27 needs massive rewrites and amendments to properly protect privacy, which should be a fundamental right to Canadians. The bill needs the balance between a fundamental right to privacy and privacy protection and the ability of business to responsibly collect and use data. It also needs more nuance. The parts of the bill are far too vague. The definition of tyranny is the deliberate removal of nuance. So to create more equality or fairness on those privacy rights and to ensure businesses and AI use data for good, we need more nuance, more detail, more explanation, not less. There is a saying, if you're going to do something, and my grandfather had this, I love it, make sure you do it right or don't do it at all. And besides the omission of privacy rights as a fundamental right, this bill needs massive rewrites. Firstly, the bill doubles down on a flawed approach to privacy using a notice and consent model in its legal framework. This legal framework of C-27 remains designed around a requirement that consent be obtained for the collection, use, and disclosure of personal information unless one of the listed exemptions to consent applies. And those exemptions are called legitimate interests. And what is scary about legitimate interests is that the businesses themselves will be determining what legitimate interests mean and which are exempt. A quote from Canada's leading privacy and data governing expert, Teresa Scazzi, says that this provision alone in the bill trivializes the human and social value of privacy. The legitimate interest provision allows Facebook, for instance, to build shadow profiles of individuals from information gathered from their contact, even those that have no Facebook access or accounts without asking for their permission. So if you ever wonder, if you ever signed up for Facebook, if you've ever seen on Facebook the people you know feature, and sometimes people that you know turn up that you have no idea how you've met, and they're not even on Facebook. You may not be at Facebook. It's because Facebook builds profiles and shadow profiles from other members' contacts. So if you ever shared your own contacts, there's a feature where Facebook will say, share your contacts. It's going to be great for you. You're giving all your friends' information to Facebook, their emails, their addresses, sometimes their private phone numbers. And what we've been found, in the US have found this, that information is turning up in Facebook. And here's a couple examples. An attorney had a man recommend a friend you might know who was a defense counsel in one of his cases when they only communicated through work email. So, and a second one, a man who donated sperm to a couple secretly had Facebook recommend the child as a person he should know, despite not having the couple that he once knew on Facebook. Right? So legitimate interest needs more nuance, needs to be more defined, or it's useless. Legitimate interests allow for too much interpretation, or in other words, allows something to be something unless it isn't. It's far too broad. Additionally, although consent is listed as having to be in plain language that an individual to whom the organization's activities are directed would reasonably be expected to understand, C-27 makes it hard to determine what legitimate interests are, and that goes back to my privacy as a human right omission complaint. If we compare the section to the European Union's Privacy Act, as the minister stated, the gold standard, or the GDPR, the legitimate interest exemption is available unless there's an adverse effect on the individual that is not outweighed by the organization's legitimate interest, as opposed to the interests or fundamental freedoms of the individual under the GDPR. If adverse effects on the individuals, which can be data breaches that are shocking and distressing to those impacted, and some courts have found that ordinary stress and inconvenience of a data breach is not compensatable harm, since it has been a routine part of life, probably for the last 2 years at least, legitimate interest exemption will be far too broad. What C-27 does is take something that in European privacy laws was meant to be quite exceptional for consent and makes it potentially a more mainstream basis for the use of data without knowledge and consent. And why does it do this? Because C-27 places privacy on par with commercial interests in using personal data, something that wouldn't happen if privacy was noted in this bill as a fundamental right for Canadians. Additionally, we need to be wary of consent, and consent should be made easier as is mandatory. Has anyone ever looked at the iPhone when you're agreeing to consent and you've scrolled down? Has anyone actually read all that? Has anyone gone and read Google pages, 38 pages of consent every time you sign up or you use Google? Has anyone ever read that? Consent is not easy. It's not simple, and certainly this law is not making it any simpler. We need to be wary of consent. And we need to ensure that consent is consensual, both in language and intent. And we all know exactly what we are signing up to do, to give, and to receive. And there's another term I want to explain to you as well, Mr. Speaker, called de-identification. In this bill, it talks a lot about de-identification as a definition that means to modify personal information so that an individual cannot be directly identified for it. Even though, and it goes on, a risk of the individual being identified remains. So you're going to lose all your information, but a risk of identifying an individual remains. Remember my TELUS Data for Good example. TELUS gave this information to the government during COVID, even though a risk of the individual being identified remained. It should be scrapped, and instead we should be using the word, which is also in there, anonymize. And this is what the GDPD does, which means to irreversibly and permanently modify personal information in accordance with generally accepted best practice to ensure that no individual can be identified from the information, whether directly or indirectly, by any means. Let me just ask you, which one would you prefer, Mr. Speaker? Would you like to be re-identified? Maybe there's a possibility, or no identification by any means. Another major flaw in C-27 is the creation of a bureaucratic tribunal instead of giving the Privacy Commissioner more bite. The creation of a tribunal is a time waster. Instead, the Privacy Commissioner should be allowed to levy fines. The Privacy Commissioner should be given more power and more bite. It's unclear because the EU, the UK, New Zealand, and Australia don't have tribunals that mediate their fines for privacy violations. Furthermore, it'll no doubt cause those that have had their privacy violated wait years for a right of action. So let me just put this straight. First, you're going to have an Ontario, or the official Privacy Commissioner, who's going to be able to make a ruling. Then the government said we're going to have then a tribunal, which could then reverse the ruling of that Privacy Commissioner. Then you're going to have the Superior Court or Supreme Court who's going to be allowed then to rule on the tribunal's ruling. So you're going to have a decision, another decision, and a third decision. Each one of them could be countered. And let me just guess how long that's going to take. What do you think it's going to take? 48 hours? 6 months? Try right now, the average is 1 year for the Privacy Commissioner, add another year for the tribunal, add another year for appeals. And so when we ask, Mr. Speaker, when the average Canadian who's had their data breached has to go up against Facebook and Amazon with limited resources and then has to spend 3 years in court, is this fair? Does this protect fundamental privacy rights? And is this just not adding another layer to government that we certainly don't need? The absence of rights-based language in the bill might tip the scale away from people in Canada, and the OPC and the tribunal weight the privacy interest of people against the commercial interests of companies. Again, what does this come back to? Privacy was not listed as a fundamental right of Canadians. And lastly, Mr. Speaker, AIDA, or the AI portion of this bill, needs a complete rewrite. It needs to be split in its own bill. I want to commend the minister for bringing this forward, and he wants to be the first one in this land to bring this part of the bill forward. But to be honest, Mr. Speaker, consultations have only started from June. We've met with many individuals who certainly have not had input in this deal, and although AI is there are many parts missing. First of all, its finding concludes that there will be no independent expert regulator in Canada for automated decision systems, nor does it have a shell of a framework for responsible artificial intelligence regulation and oversight. Instead, it says the regulations will be determined at some future date, and decisions will come from the Minister of Innovation, Science and Economic Development or a designate. Again, that part of this bill includes a new tribunal and puts decisions where they shouldn't be, into the government. Enforcement and decision-making of the minister or the minister's designated ISED official, political decisions on privacy. Does everyone feel comfortable that we're now shifting from a tribunal to the government? This part of the bill will shift all of that to the government, to the minister or his designate. It reminds me of the proclamation, hey, we're from the government, we're here to help you. There's no mention of facial recognition technology also in this part of the bill, despite our reports that have come from the Ethics Committee, the examples I gave from before on FRT. And certainly that is worth more study. Mr. Speaker, there are some parts of the bill that are good aspects, and certainly that we can get behind. The protection of children's privacy, and as a father, it's so very important. Our children now have access to all kinds of different applications on their phones, on their iPads, on their Amazon Fires. Our children are listened to, they're surveilled, and certainly there is no question that businesses are taking advantage of those children, and that's something that we definitely need to talk about. The attempt to regulate AI, though, as I've stated, needs major revisions. And without a proper privacy statement, it does not have a balanced purpose statement, establishing that the purpose of the CPPA being to establish rules to govern the protection of personal information in a manner that balances the right to privacy and the need for organizations to collect, use, or disclose personal information. But we should be shooting beyond the European Union's Privacy Act, shooting to be the world leader in the balance of privacy protection and ensuring businesses and industry use data for good, and doing so attracting investment, technology, and all the while protecting Canadians' fundamental right to privacy. Canada needs privacy protection that builds trust in the digital economy where Canadians can use new technologies for good while protecting them from the bad, profiling, surveillance, and discrimination. The minister said, we want to seize the moment. We need leadership in a constantly changing world. And most importantly, the minister said, trust has never been more important. If we don't get this right, if we don't make sure that privacy is a fundamental human right and declare that in the document and to build the document around that right, we're doing two things. We're not prioritizing Canadians' privacy. We're certainly not putting privacy in the forefront of the bill. We're certainly not showing leadership in an ever-changing world. As I noted in my onset, the technologies 22 years ago have changed so significantly. The technologies now are changing more significantly. In the next 22 years, we're going to have technologies that certainly are more embedded, not less, in our lives. We're going to certainly have AI that do good. One of the stakeholders we met with actually talked about AI for good. They talked about embedding AI into the government system of passports might actually mean we can get passports within 48 hours. Can you imagine that? Technology for good. Embedding that to a system that will allow Canadians to get the things they need more often. Mr. Speaker, we love technology. We want to embrace it. We just want to make sure, number one, privacy is protected. We want to make sure we do the hard work of building frameworks alongside Canadians' right to have their fundamental human rights to privacy to be protected in equal balance with the economy, democracy, and the rule of law. This bill does not do that, not yet. And Mr. Speaker, let's work forward to make sure that we come back with a bill that does that. Thank you, Mr. Speaker.
Questions et commentaires.
Questions and comments. The Honourable Parliamentary Secretary, to the government leader.
Mr. Speaker, and I thank the member from Bay of Quinte, my neighbouring riding, for his intervention today. But I must say, I found it to be quite fascinating. He spent a lot of time talking about fundamental human rights and rights-based language, yet the Conservatives' provincial cousins in Ontario today are literally trampling all over those rights by using the notwithstanding clause in legislation to force people to work before even allowing a court to weigh in on whether or not it's appropriate or the law that they created was appropriate. So I'm wondering, with all this talk about fundamental rights, would the member agree that these should be rights that are not subject to a notwithstanding clause, or should not be able to be trampled all over like their provincial cousins are doing in Ontario right now?
The honourable member for Bay of Quinte.
Mr. Speaker, I'm disappointed in that question. We're talking about privacy rights for Canadians. If we want to talk about children, we're talking about protecting children's privacy rights, which are being absolutely discriminated against. They're surveilled every single day by big data. We want to protect their rights on privacy. And I know the member across from me is my neighbor. I know he's also a father. So when we talk about just how much of our children's information is out in the world, how much it is being data mined and sold to other countries and other companies, that is what's concerning to me. I think I would love to hear questions about this bill and how we're going to better it, and therefore better our children's futures in a digital age. Thank you, Mr. Speaker.
Questions and comments? The honourable member for Winnipeg Centre.
Thank you, Mr. Speaker. And I know that there was some discussion about rights, and I heard my Liberal colleague across the way calling on the Conservatives questioning why they are staying silent while Doug Ford takes away the rights of workers. I found it peculiar that my Liberal colleague did that, considering they forced postal workers back to work. But I'm wondering, the member from Carleton has stayed silent, and I'm wondering if they support their buddy Doug Ford taking workers' rights away. Thank you, Mr. Speaker.
The honourable member for Bay of Quinte.
Mr. Speaker, thank you. Once again, I'm disappointed. I guess the Liberals and NDP don't really care about privacy rights for children, which we're talking about today. This is fundamental to this bill. The minister has spent a lot of hard work putting this bill together, and there's been a lot of consultations. This is a second iteration. C-11 was first. It died only because there was an election called. Now we have C-27, which is very serious when we're talking about the rights that have been trampled on for our children, for Canadians. I gave a lot of different examples where we just have not got it right in terms of protecting children. I'm just surprised that the NDP also, it seems, don't seem to think that privacy is a fundamental right, something that we should have protected. And certainly the Conservatives think that we'll be protecting it. We're the only ones speaking about it today. Thank you, Mr. Speaker.
Questions and comments, the honourable member for Trois-Rivières. Thank you, Mr. Speaker. I'd like to thank my colleague from Bay of Quinte with whom I worked on the Ethics Committee, and we miss him very much. He made a point that's very important in my opinion. He said that in the bill, privacy wasn't treated as a fundamental right. And I'm very interested in that because the Privacy Commissioner mentioned that as being an essential condition for moving forward. I'd like to hear what he thinks about that. The honourable member for Bay of Quinte.
Thank you, Mr. Speaker. Through you, it is absolutely essential. If we have the loss of privacy as a fundamental right, and even in this bill where we put it in par with business, then when we get to the courts, when we get to people who have had their rights trampled on, when people see that their home addresses, because they donated to something, are put on the internet for everyone to see, we lose what we value as individuals, as a Canadian and as a Canadian society. We lose the protection that all of us have the right to live a great life, to volunteer and do the things we want to do, to pursue that which motivates us the most, not because man or God says it's the right thing to do. It's because it's our natural rights as Canadians. It's what we tout to the world as our freedom. Protecting that is paramount. And when we have laws that go out to protect that and to have the ability to look after that, but we don't mention that in any part of the bill, we're missing that. And what the biggest problem with the bill is when it goes into law, if it's not in the bill, then courts are left and businesses are left on their own definitions of what that means. Like I talked about legitimate interests. It has to be in this bill from the onset. It's in the European Union's bill. It's in the Quebec's privacy bill. Why isn't it in the Canadian bill when we're presenting to Parliament? Thank you very much.
Questions and comments. The honourable member for Calgary, Rocky Ridge.
Mr. Speaker, and I thank the member. I listened to his speech. He talked about some of this goes to sort of the general approach of this government. We have a bill that purports to have noble objectives that we might agree to as objectives, but there are all kinds of problems with this bill. And he talked about how much of this bill is left to future regulation, and we've seen this before, where the bills lack details. They give the minister future powers. We don't know how it's what the final system is going to look like. But the members was on the ethics committee when we studied artificial intelligence and facial recognition. We had a great report that had unanimous support from all parties, including the Liberal members of that committee. But this bill was already tabled, and we really were just beginning to scratch the surface, it seemed. So could you maybe comment on some of the recommendations that came out of the ethics report and the problem with just leaving so much to this vague future regulation?
The honourable member for Bay of Quinte.
And thank you to my honorary colleague. A great question. We had a great study in ethics, and we've just started to scratch the surface, as he mentioned, on looking at what has happened because of this technology and where is it going. Facial recognition technology, as we mentioned, Clearview AI was a company that scrapped images off the internet and just gave it to law enforcement. One of the biggest concerning investigation report, part of the report we had, was that when facial recognition technology was used, it misidentified black women 38% of the time. And that's very, very concerning. When we asked law enforcement, did traditional technologies like fingerprinting do the same? It does not. You know, this technology isn't perfect, and therefore we need a lot of study on it, a lot of consultation. We certainly haven't had that. Our recommendation is to make sure we have tremendous consultation on the AI portion and perhaps scrap that until we're ready to present it. Thank you, Mr. Speaker.
Questions and comments. The honourable member for Kitchener Centre.
Thank you, Mr. Speaker. I want to start by recognizing that tensions are high today with respect to workers' rights, and I appreciate that colleagues of mine have brought up the important being mindful with respect to a province has invoked the notwithstanding clause to trample on workers' rights, and that the federal government has the power of disallowance in the Constitution with respect to overriding that. I understand the member for the Bay of Quinte doesn't want to speak about that, so I'd like to ask a question related to Bill C-27, and that's with respect to political parties not being required to protect consumers' private data, and this gap not being addressed in the current version of C-27. I'd like to know if the member for the Bay of Quinte is concerned about this, as he's concerned about a number of other items in C-27, and if so, if you'd like to speak about that.
The honourable member for Bay of Quinte.
Mr. Speaker, thank you, and I want to thank the member for bringing the subject back to hand. And I've heard of this, I've read about it, and it is concerning to look at it. There's two parts we're looking for privacy, right? Privacy number one is C-27, which protects Canadians' private rights when it comes to business. The second side is the Privacy Act. We haven't looked at that, and that needs to come back to Parliament as well. The Privacy Act pertains to everything that government holds and controls, and how much information the government gets to keep of Canadians as well. So those two are very important. And to that point, to the member, certainly political parties as well. I think we all have to be responsible with private data. We all have the right as good citizens to collect it where it's going to be good, but where it's bad, the points I brought out before, using personal information also for political gain to identify where people live because you don't like where they donated to, absolutely irresponsible, and I hope the member agrees with that as well. Thank you.
We have time for a short question. The Honourable Parliamentary Secretary to the Government House Leader.
Agree with this member on that. My question to the member, Mr. Speaker, was how is he going to ensure that those rights that he wants so badly are not trampled on like what we're seeing today?
The Honourable Member for Bay of Quinte in 40 seconds.
Mr. Speaker, the first thing that starts with this bill is that we ensure we get it right, include fundamental privacy rights in this bill. And if this member is so concerned about that, I'm hoping that he's going to join our side with amendments to ensure that is absolutely the starting place for this bill. If we're doing this in this Parliament, here in this place, we're going to do everything we can to ensure fundamental privacy rights are included in this bill, and that going forward we accept nothing else. Thank you, Mr. Speaker.